Well, Monday, the U.S. Supreme Court will hear two cases, one involving Harvard University, the other the University of North Carolina at Chapel Hill, challenging the constitutionality of race-conscious admissions policies. Joining us now to discuss is our legal panel, constitutional law attorney and legal analyst, Amir Benno. And also with us is the distinguished university professor at Touro University, Thane Rosenbaum. Amir, Thane, great to have you both with us. This is a really interesting case. I feel like we've been talking about this for so long, and now we're going to finally hear oral arguments. Amir, I want to kick it off with you with a focus on the Harvard case, which is going to consider whether Harvard discriminated against Asian American students in its admissions process. Talk to me a little bit about what you think we're going to hear on both sides of this issue.
Well, we're going to hear on the side of those who want affirmative action to say that it adds to diversity in the schools, and that diversity is an important educational benefit. On the other side, you're going to say, wait a minute, this is crude racial stereotyping. You're saying that because somebody has a particular skin color or looks a particular way, they must have had a certain set body of experiences in their life, or they must automatically subscribe to a particular set viewpoint. And they're saying that's just crude racial stereotyping. It's not that way at all. And we should move to getting a colorblind constitution. Justice Roberts has said it many times before. The way to stop discriminating on the basis of race is to stop discriminating on the basis of race. And that means across the board. And it should be on merit. It should not be on skin color, race, or your ethnic background.
Thane, I'm very curious to get your legal perspective on this, but also the fact that you are a professor at Touro University and sort of what you make of the different dynamics in both of these cases.
Well, Kilmeny, first of all, remember one other argument that you'll hear from supporters of affirmative action is it's been 40 years and we have a reliance interest in this. Of course, the exact same thing was said on behalf of people who were supportive of abortion rights, right? That we were in reliance of it. What's interesting about this, Kilmeny, is that like the Dobbs abortion case, this case would invalidate affirmative action as we know it. And that's usually like what we saw in Dobbs, unusual, where you have a sweeping overturning of a long-established precedent. So it's interesting that in both terms, both for abortion and affirmative action, these cases are not looking to chip away at something. As Amir said, this thing is basically saying this is racial stereotyping. It violates the Equal Protection Clause of the 14th Amendment. And therefore, and they're not necessary, that they can be achieved, what universities would say, and in states like California and Michigan, which have now prohibited affirmative action, they say we can
All right.
Minorities.
Oh,
that's
you're back.
The way we achieve the same
You
result.
just froze for just a second, Thane, but we got you back. Amir, I guess this has gotten a lot of attention also because we have seen the court on these other cases upend decades of precedent, and there's no reason to believe that they wouldn't do the same thing in this case necessarily. But have we had any indication of how the particular justices view these issues? We know that Ketanji Brown Jackson, Judge Ketanji Brown Jackson, had said that she would recuse herself from this case.
Well, in one of the cases, they've separated them. She was on the
Harvard,
board of overseers of Harvard, so she's recusing herself from that case, but not the UNC case. But yeah, we know how they're going to vote because Sotomayor and Kagan have made it clear, and Ketanji Brown Jackson as well, how they would. Back in 2016, the last time they dealt with this in a case called Fisher, you had Sotomayor and then Justice Breyer and then Justice Kennedy and Justice Ginsburg in the majority. It was actually a 4-3 decision because Justice Scalia had died and Justice Kagan recused herself, but they were in favor of affirmative action. But the ones who were opposed to it was everybody else who we have now: Thomas, Alito, Chief Justice Roberts, and now we of course have Gorsuch and Kavanaugh and Barrett. So we know that the weight is on overturning this. And to Thane's point, they're going to argue the side that favors affirmative action that there's a reliance interest, but nobody has an interest, a legitimate interest in discriminating against people on the basis of their skin color. So really, I think the justices are going to find that there is no reliance interest here, and the other requirements to overturn precedent have been met.
All right, Thane, any final thoughts?
Yeah, wild cards. Justice Roberts doesn't like dramatic changes in precedent, and that's why he didn't vote to overturn Roe v. Wade. He just voted to support the Mississippi law. And guess what? Kavanaugh, who is known as a conservative, tends to hire minority students, both as a federal appeals judge and now as a Supreme Court justice. So it'd be interesting to see whether he votes along with the conservatives or he has a perspective, a different perspective, since he's hired so many law clerks who are minorities.
All right, Amir Benno and Thane Rosenbaum, we appreciate you being here. Thank you.